Earlier this week, the Department of State Services, DSS, filed a 5-count charge against activist and publisher Omoyele Sowore, accusing him of using his social media platforms to defame President Bola Tinubu by calling him a criminal. The suit names Sowore, Meta, owners of Facebook, and X-Core, alleges that his posts are false, malicious, and capable of inciting public disorder. The DSS claims Sowore's violated provisions of the Cybercrimes Prohibition, Prevention, and ETC Amendment Act 2024.
But in response, Sowore has countersued the DSS, Meta, and X, claiming that their demands to delete his post amounts to unconstitutional censorship, a breach of Section 39 of Nigeria's Constitution, freedom of expression. His legal team argues it's not just about his comments, but about a wider danger. State agencies exerting control over what can be said online. This tension pits the law, especially recent laws on cybercrime and hate speech, against civil liberties, public criticism, and, well, precedent. Does describing the president in strong terms cross legal lines of defamation or false statements? Or is it protected political speech, even if uncomfortable for those in power? Instances of legal friction over speech in Nigeria are, well, not new. We've had so many of them in the past. Prominent figures have faced defamation, libel, or sedition charges over statements critical of the government. In many cases, authorities have acted on complaints to social media platforms on leveraged laws, ambiguously written to hold activists to account. Critics say this pattern reflects systemic issues. Thus, they have been calls for civil society and legal experts for clearer guidelines, restraint from law enforcement, and stronger protection of free speech so that criticisms of government does not become criminalized. So let's welcome our guest to take us through the specifics. We have Ashok Philip, who's the National Organizing Secretary of the African Action Congress, AAC. We have Todimu Ige, a lawyer based in Lagos, and Abdulkarim Musa, Sowore's lawyer. Gentlemen, good morning, and thank you for joining us. Thank you very much, gentlemen.
So I think I'd like to start with Mr. Todimu, who's here with us in the studio. So Mr. Todimu, let's talk about the Cybercrime Amendment Act of 2024. It says that, are we going to say that, what does it exactly say? And does Sowore's post clearly violate that section? And if so, how?
Now, the provisions of the Act have stated that if you make a statement that tends to put the other party in a bad light, particularly if the statement is false, and the intent of that statement is to incite reasonable persons or the society against the person, then you have crossed the line. Now, if you look at the speech by Sowore labeling the president as a criminal, the president has not been convicted as of today by any law within the definition of the Constitution of the Federal Republic of Nigeria.
Right.
And now, if we say that the president has not been found guilty by any competent court in Nigeria, his statement is saying that the president is a criminal. You would see that if he can corroborate or substantiate that, then we will say that he is right. But if he is unable to prove beyond reasonable doubt that the president has been convicted, that it's not about, it's an opinion. And your opinion must be very clear not to incite the public against the other party. So, if you look at it, if you juxtapose the position of the law and his statement, then you will see that clearly there is a form of infringement.
I'd like to take Mr. Abdulkarim Musa's take on that same question. Abdulkarim, are you with us? Can you please, let's have your take on that question. Go on, Abdulkarim.
Yeah, are you with me?
Yes, we are. Go ahead.
I've consistently maintained that statements made by persons on matters of public interest, particularly as it regards with regards to political office holders, cannot be taken in light of the definition that my colleague just gave as to defamation. If Nigerian makes a statement concerning issues that are of public interest and with the intention of scrutinizing the action or the statement or the policies of government, such statement cannot fall within the confines of defamation. And if we may, examine this issue even deeper, the prosecution of Mr. Sowore on the alleged offense of defamation does not take cognizance of the provisions of the Constitution, which is the highest law of the land. Because in your interpretation of whatever law you are deriving the offense of defamation from, you must give due credence to the Constitution. For in Section 1 of the Constitution provides that if any law is inconsistent with the provision of the Constitution shall prevail, and that other law shall, to the extent of its inconsistency, be null and void. The Constitution is not just a document, it has a spirit, that is the essence. It has the values upon which the Constitution was made, and any law, in interpreting or construing the provision of any law, those values must be taken into consideration. So if any law like the Cybercrimes Act, if Mr. Sowore is said to have contravened any law, in interpreting that law, the Cybercrimes Act, whatever agency is prosecuting him ought to take cognizance of the provisions of the Constitution, whether or not the alleged offense of defamation is consistent with the provision of Section 39 of the Constitution, which provides that Nigerians have the freedom to express themselves and hold opinion.
So, Mr. Abdul Karim, I wanted to know, where do you stand on the details of the Cybercrimes Act? Do you stand on the side where it's a proper document, or do you think that it's infringing on people's rights, especially when they have to express on social media, which could be considered as publishing information?
Yes, I have consistently maintained the position that the Nigerian law enforcement agents have engaged and utilized the Cybercrimes Act to muzzle Nigerians into being unable to speak. Just like I said earlier, they are not interpreting, construing, and applying the Cybercrimes Act in line with the provision of the Constitution. They are not interpreting and applying the Cybercrimes Act in line with the spirit, the values of the Constitution. The Cybercrimes Act, the origin of the Cybercrimes Act of 2015 was when Nigeria started becoming noted for offenses, internet crimes, offenses that relate to social media and all that, and it began to give Nigeria a bad name even in the international community. There was a need to enact a law that would curtail the practices of maybe people defrauding other people, people hacking people's account online, and that was the idea. Though there are a little bit of provisions in the Cybercrimes Act that deals with making comments and all that, but the way the law enforcement agents in Nigeria are utilizing the law now is to oppress and repress free speech. If anybody makes a statement that seems to offend any political office holder or the who is who, then the Cybercrimes Act is engaged to prosecute these people. That is an abuse of the essence of the Cybercrimes Act. For every law, there are mischiefs for which laws are meant to curtail. There are mischiefs for which laws are meant to cure. But the way the Cybercrimes Act is being utilized, it does not show that the law enforcement agent really understand the essence of this act.
All right, let's come to Mr. Oshoks now. I have so many legal questions to ask the two lawyers that we have here, especially seeing that you both have very slight differences. But let's ask Mr. Oshoks. Regarding particularly, well, when it comes to speaking, when it comes to political dissent, what hope do we have for people who have varying opinion from governance, especially when it comes to the aspects of publishing thought or opinion on social media?
Yes, thank you for having me. The issue goes beyond Sowore as a dissent voice, as a voice of the voiceless in Nigeria. It directly speaks to the health of our democracy. You know, when citizens begin to speak up against misrule, corruption, against all forms of injustices, then that should not be classified as hate speech. Rather, they should be applauded for doing so. And this is what every, discerning democracy should embrace, You cannot begin to criminalize criticism or label dissenting voices like that of Omoyele Sowore to say he's committing an offense, So for some of us, we feel and we know that Omoyele Sowore is somebody who has always spoken truth to power. And in this instance, he's doing the same thing. And we know his precedent, we know where he's coming from, we know he's been into this for over 30 years and counting. And he has always, stood on the path of truth, on the path of justice, and on the path of growth for the country, So putting these cases to, gag him like he's committing a heinous crime, we believe that is just a way for the government to try, stifle the civic space. And this is where some of us are, crying out to say, no, this is uncalled for. The government should retrace her steps and then do the needful. And then, the biggest form of national security right now is weaponizing security agencies like DSS to go after dissent voices who tries to speak truth to power. And Omoyele Sowore is one of these voices who has consistently and unapologetically spoken truth to power without fear or favor, regardless of who else is God. And this is our stand, this is our position. It is not a crime to call a thief a thief.
Right. Wow. So, Mr. Todimu, let me ask you now, can you tell us about, the countersuit by Sowore for the constitutional right violation? What is the scope and the strength of the argument?
Well, like his lawyer mentioned earlier, that Section 39, what Section 39 of the Constitution of Federal Republic of Nigeria says is about, it talks about freedom of expression. Now, freedom of expression means that you could express how you feel. But there is a borderline when you begin to say what is false, when you begin to cast aspersion on the other person.
As false is subjective.
Yes. Now, I give an earlier interpretation that, yes, false is subjective. What is the test? Is there any competent court of jurisdiction that has pronounced the president as a criminal? That's the test. If there is any, anybody could accuse anyone of any crime. And Nigeria, the law is very clear. The Constitution says that anyone is free, or everybody is innocent until proven guilty by a court of competent jurisdiction. And that is what is lacking here. Nobody is, of course, I'm a strong proponent of saying that, yes, Nigerians need to speak up. Nigerians need to defend their rights, but we need to be careful about the language. Two wrongs don't make a right. If you are going to be given an expression, of course you can speak clearly against the activities of the government, but we need to ensure that whatever we are doing is in line with the provisions of the law. And that is what I'm saying, that yes, the cybercrimes are of course, there are times that the security agencies can be overlapping, they can be, overbearing. But we must be very careful that two wrongs don't make a right. He has said that Section 39 guarantees freedom of expression. Very well. But now, what we need to now check, and the test is the president a criminal? Has he been convicted by a court of competent jurisdiction? No, I don't think so.
Now, this goes to both you and Abdul Karim. Does the factor that this was published have any toll on the events? If he had simply expressed it, would it have had a different trajectory? Was it because he put it on social media? And what obligations do these social media platforms have? Did they need to acquiesce to the demands of the DSS? Let me start by asking Abdul Karim. Abdul Karim, was publishing that statement the contention? First off, let's start there.
Well, there are several laws that criminalizes making statements even when they are not published. So the publication is not really an issue, because even if it was not published on that platform and it was maybe statements were made in the presence of other Nigerians, they could still find offenses under which they would charge the maker of the statement. But just in line with the other questions that, and in line with the discussion that my colleague just had now, that until a person has been convicted by a court of competent jurisdiction, that I cannot address the person as a criminal or a thief. That is not the law. The law says that every person who has been alleged to have committed an offense shall be presumed to be innocent until proven guilty. It is a presumption, but it doesn't mean that if you enter into my house and you steal my property and I catch you, I will not call you a criminal. If I find my property, you have attempted to dispossess me of my property with the intention of permanently dispossessing me of same, I cannot call you a criminal. So it is a presumption of law.
Abdul Karim, this is presuming. So now what you're making me presume is that Sowore does have facts that lead to him calling the president a criminal. Because if you use the analogy of me walking into your house and you catching me stealing something, then you can call me a criminal. So does Sowore have these facts that have led him to call the president a criminal, is the question.
There are plethora of facts, even known to the Nigerian people, that the president and his cronies are dealing with Nigerians in ways that are unlawful and illegal. There are many situations that we can point to as to how the president has conducted himself unconstitutionally. There is a case of Rivers here where the president imposed a military man there for no justifiable cause. There are cases where the president has been indolent when thousands of Nigerians have been killed, and we can argue that that is complicit. He was complicit in those actions. So that is a different discussion for the courts, for Mr. Sowore to put forth justification for his statement, because justification is a defense to defamation. But the most important thing that I want us to point our attention to is the fact that this matter is not such that should be charged to court. It's not such that a citizen who made a comment following his interest in a public matter should be charged. It is a very dangerous precedent of gagging people from being able to criticize and analyze government. Because if you are subjecting, and I've said it over and over again, that the standard that is imposed on people when they make statements against public office holders or government institutions cannot be the same standard that is imposed upon persons when comments are made against ordinary citizens. So you cannot, if I had made a comment against a businessman or an ordinary Nigerian who did not occupy any political office, who did not run for any political office, who is not tampering with anything that I have or that the Nigerian people have an interest in, then you can say that I have defamed the person or I have defamed that institution. But when somebody put himself forth as the president of Nigeria, or that he is dealing with critical interest of the Nigerian people, you cannot stop me from analyzing and criticizing and even calling him out on issues that I feel
Abdul Karim,
he has not conducted himself properly. All right, then, Abdul Karim.
Let me come back to the studio with Mr. Todimu here. What obligations do the platforms have? Do they have any obligation to comply with the DSS's request for the tweets to be taken down? Did they?
Well, if you look at the platforms, they also say that they protect their community and ensure that people don't use the social media to incite violence, that people don't use their platform to commit crimes. Now, to that extent, they are a body. And of course, over time, the Nigerian government and even governments in other climes have tried to ensure that the social media is not unrestricted, to avoid instances of hate speech, to avoid instances of people inciting violence within their jurisdiction. So to that extent, the DSS does not have the capacity or the power to bring down the post on their own. What they can do is to also, make a case to say, we feel that what has been stated on this post violates your terms and conditions, violates, the tenets of fairness and equity. And to that extent, they can demand or they can request that the post be brought down. So to that extent, I think that the DSS is right, as opposed to, forcefully bringing out the post or forcefully, doing any other.
Yes, taken down. Okay.
So I think my question will be for Abdul Karim. You mentioned that, the post was also made for the people, so public post for, I'm assuming, for the benefit of the citizens. And you were talking about free speech. So my question would be, where is it written? Is it okay? Is it under the law that, it's okay for the citizens or someone to come out for the citizens to call the president a criminal?
As a representative?
Yes, it is the law. It is enshrined in our law. One of the ways you know laws that are applicable in our jurisdiction is through case laws. If you visit the case of Becky versus Becky in 2012, if you check the Law Pavilion Electronic Law Report, you find where the Court of Appeal of Nigeria held that Nigerians are entitled to make comments on matters of public interest. This includes making comments as to whether or not a public office holder has conducted itself criminally. In such case, if I describe the conduct of a political office holder as criminal, I'm not guilty of defamation.
Okay. Abdul Karim, thank you for being summary in that last submission here. Mr. Oshoks Phillips, please do beg our pardon. We didn't forget you. I was saving this one for you. Now, in America, there seems to be a similar issue where a TV host has been taken off the air. He's been suspended because of remarks that he made regarding comments that Donald Trump made or didn't make. And that has caused him to be taken off air, which has caused people to react, saying that that doesn't seem like freedom of speech. Where's the First Amendment? Here in Nigeria, we're seeing something similar happen. At least that's what people are interpreting it as. So what does that say for my freedom? What does that say for my ability to actually perhaps maybe note something that might be on a dissenting note? What's that saying for all of us, regular people, and our freedom of speech in Nigeria? Mr. Oshoks.
Yes, freedom of speech is not guaranteed by the government. It's a fundamental right. And every dissenting voice has the opportunity to express themselves, especially in situations where they find not palatable as freedoms and as citizens. And in Nigeria, and in the case of Sowore and Tinubu, it should be noted that Tinubu is a citizen of Nigeria. And the very day he presented himself to be president of this country, regardless of how he came into power, he becomes, answerable to every Nigerian of repute. So criticizing the president has no way, pushed Sowore off balance or off track. Sowore is still on track. Sowore has been a voice that will continue to speak truth to power. So if any individual who stands today to criticize the president, that person should be applauded, because this is what democracy should be all about. This is how we put the government in check. So social media as a tool to express ourselves should not be gagged for any reason. We see what happened in Nepal. Nigeria should be very careful. Nigeria should be careful how they use instruments of state against social media, against individuals of dissent voices who try to speak truth to power. Because it is Sowore today, it will be any Nigerian who decides tomorrow to dare speak truth to power. So all we are saying is, regardless of what has happened in other claims, we are more concerned about what happens within our own geographical space and how we hold governments accountable. So Sowore is on track. Sowore has been doing this, and we will not, for any reason, consort to any form of intimidation by security agencies that have been bought by the government, who are only bent on doing the biddings of the government. And the government have been able to define hate speech just to suit their own narrative and not what it really is. So for us to speak truth to power and ask everybody who have taken public office to account, that is not hate speech, that is freedom of speech. And that is also, we have the backings of international conventions, just like the African Charter on Human Rights and People's Rights. So we know all where this is coming from. It's just a way to push Sowore, who has a very clean slate, gag him. The DSS are just, in Nigeria today as we speak, there are those in government who on daily basis churn out hate speeches, but these people are not even called for questioning. Even the minister today, we see how we come to brandish all sorts of, statements on live television and call all media houses in Nigeria, and they grant him, and people applaud him because he's in government. So when an activist like Sowore of a reputable status decides to say, this is what I feel about governance, then all, hell will be let loose. All, security agencies are running helter-skelter just to please their paymasters. So this is what we are saying. Freedom of speech is not hate speech, and we must be able to draw that line. And we shall continue to express ourselves to ensure that we hold government accountable any day and at any time. And for all Nigerians and all media houses should continue to do the same, because trying to, even the attempt of gagging Omoyele Sowore is not about him, but about every other Nigerian. So we will not take that to continue to speak truth to power, and Sowore will not, fall into any form of intimidation or allow them gag him in a space where, in short, is equal to the tax. That is what I will say on this.
Thank you very much.
So we are standing on that. And when the government feels dissent voices becomes hate speech, it is not protecting the citizens, but just protecting those in power. And that is where we stand.
Thank you very much for that stance there. Let's talk to the Ige here. I was wondering, at the case of Dele Farotimi, was there any lesson to be learned, and how does that apply to what we are seeing here with the case of the DSS and Sowore?
Now, the truth of it is that Nigerians, our rights to freedom of expression is clearly protected in the Constitution of the Federal Republic of Nigeria, Section 39. And of course, now where the decision is when not to cross the line. You can be a strong critic of the government. You can express yourself without being abusive, without issuing false statements or hate speech. That's where we must draw the distinction. That freedom of expression, yes, you have a right to do that. And nobody, ordinarily, it must be...
But then an extended question is, shouldn't the government or the DSS or the whatever authority have considered it as a presumption? Because just like you're guilty until you're presumed, what's it called? You're presumed... What's the word again?
Innocent until proven guilty.
Presume now is a very critical word here.
Yeah.
Yes.
But it doesn't seem like as if it's being presumed or he's being presumed innocent at this point. It's like I said, why should you have said that? It's no longer a presumption.
No.
A case of presumption.
Well, I beg to differ, because if the DSS or the authorities feel that he's guilty, the next thing is they would have arrested him
If they
and put
feel
him in
he's
jail. Yes, presumption. I'm talking about the word presumption that you used. Presumption. They have gone to court to say the court is the arbitral person here. We have come to say that Sowore has defamed the president. He has, of course, I don't think it's hate speech. It's defamation. That's a more suitable language. And now they have gone to court for an interpretation or a pronouncement to say that we are not comfortable with Sowore calling the president a criminal. We feel that is a breach. Now the court will not rule on it. On the other hand, if it wasn't a presumption, they would have arrested him. And
okay. So based on that ground,
yes.
that's why they're still operating with him being a free person.
Very well. So.
Okay. Yes. Interesting. But you were telling about Dele Farotimi in that case now, and what lessons could have been taken from there and applied here, or were they none at all, or are these two cases absolutely similar?
Well, you will see that in the case of Dele Farotimi, there have been instances that he has been, over time, even before now, the state would ordinarily, when somebody issues, defames the president or speaks against the government of the day, you see that they are picked up, they are arrested and thrown in prison, they are detained for a long time before they are charged to court. But in this instance, they have gone to court before any form of arrest. So it means that we are evolving to resolving these issues more civilly. And of course, because that is our advocation, that the government must not guard freedom of expression. The government must not clamp down on dissent voices. What we must do is we go to court to ensure that these issues are addressed. And of course, we look forward to the declaration of the court. This way, at least, this matter could be settled, and we are very clear as to what the limit of our freedom of expression is.
Interesting.
Right. So, Mr. Oshoks, my question would be, what remedies or safeguards should be put in place, to balance the two competing needs, preventing defamation or incitement, but preserving, robust freedom of speech?
Yes, this engagement should be all-encompassing. We have civil society groups, media platforms. They should all, begin to air out to ensure that even when the government tries to gag individuals who tend to speak truth to power, they should place the government on that, alert to understand that, look, you are crossing the line. It is not all the time that citizens cross the line. Most times the government also cross the line, but who does check the government? Who does checkmate the government? It is civil societies and as well as media platforms. But we can understand how they have gagged every kind of spaces they feel would be a threat to them. And for some of us, we feel, and we are of that very strong opinion, that the government itself should sit and do the rethink to understand that citizens have the right, citizens can always air their views, especially for issues that affect them directly, and not because statements are said and it offends an individual and then instruments of state are deployed to begin to harass and intimidate Nigerians. We must be able to, stop that at this point of our democracy, because for some of us, we feel, weaponizing the security agencies against Nigerians, it is totally wrong and it is uncalled for. Silencing Sowore on an attempt to silence him doesn't even, kill the truth. It doesn't silence the truth. It rather makes it louder. And there are issues that bothers us as a nation today that we should be more concerned about. Banditry, kidnapping, and what have you. So many forms of criminality all over the country. Those are where we should channel our resources and the manpower we have, and not weaponizing them to go after individuals who are asking public officers accountable for stewardship. So at that point, this is where we should all converge, all stakeholders, every citizen, even the lawmakers who we believe are also part of the problems of Nigeria today. It is high time they came together to begin to ask questions, to begin to draw the line between hate speech and free speech. For us, this is a free speech. This is a speech said by Sowore to express what he feels. They have gone to court, and we employed the DSS to also ask the president to come to court to tell the world how Sowore has defamed him. We believe Sowore has every right to call the president a criminal, as he has alleged the president to be a criminal, and there will be proof to show that, yes, this is why he has made such statement. And he has been able to also sue the DSS as well as other media platforms, not to take down his...
Wow. Seems we're having a connecting issue. But thank you so much, gentlemen. Oshoks Philip, Abdul Karim Musa, and of course, Todi Muwige. Thank you, gentlemen, for joining us this morning and having to discuss, this situation with us. We appreciate it.
Thank you indeed.
Thank you very much.